and genres. From, from the start, we sought to reimagine the form of the book review itself, encouraging writing that moves beyond summary to engage deeply, reflectively, and creatively with the world a book opens. Over time, we grew into a biannual academic journal that now includes reviews, explainers, commentaries, and research essays. Each issue is built around a central theme, bringing together diverse voices that explore the intersections across social sciences. Beyond the journal, TheDaak has now grown into a vibrant collective. Through our reading groups, we meet every month to discuss a shared book, discovering new perspectives through conversation. Through TheDaak Weekly, we publish personal essays, topical reflections, and explainers that extend our conversations in the present moment. TheDaak Baithak is our humble attempt to huddle together a small gathering of scholars, writers, students from different fields to present ideas and initiate dialogue, bringing critical conversations to life. Session today is a panel discussion titled Interfaith Marriages, Love, Religion and the State. Our speakers are Dr. Manisha Chachra and Saumya Maheshwari. Dr. Manisha is a political scientist whose research lies at the intersection of gender, religion, and political studies in contemporary India. With a PhD in political studies from Jawaharlal Nehru University, her work explores interfaith and intercaste runaway marriages in Delhi and Lucknow. Saumya is a doctoral researcher at the College of Law, SOAS, University of London. Her research explores the work of anti miscegenation and anti conversion laws in the lives of individuals in interfaith relationships in Delhi NCR. Our discussant for today is Khushbu Sharma, a doctoral researcher at the Center for Political Studies, JNU. Her work focuses on gender and honor based violence, caste mediated matrimony, and the politics of intimate relations in India. I welcome you all. For the speakers, the format is generally that the speakers speak for 20 minutes each. Dr. Manisha, we can start with you. You can present your presentation, and post which we will have the discussant coming in and sharing their insights or questions that they have for 10 minutes. Of course, you can take 5 minutes more if you want for the presentation, but largely around 20 to 25 minutes. Thank you so much. You can start now.
Thank you. Thank you for the introduction, Chachra. Okay. I hope you all can see my screen. All right. So this is, as the abstract said, this is borrowed from my doctoral research on runaway marriages, which was a study of intercaste and interfaith runaway couples in Delhi and Lucknow. And because this is largely on interfaith alliances, our topic, but my framework to look at it would be runaway marriages, because that's what I have largely looked at in my study. And it's a developing work, so your feedback, your suggestions would be welcome. But what I am trying to do from this, like what I'm expecting from this conversation is we critically engage, and I would throw questions at the audience, and we really think together on those subjects, and maybe have some not so linear responses, because answers are going to be complex, I think. So just to begin with, as I said, this is based on a certain framework of runaway marriages. The framework relies on runaway marriages. So as to define runaway marriages for me meant marriages which are happening without parental consent. And that became my defining factor to understand the journey of these couples. So entry point to understand the journey of these couples was what happens when the community rejects. What happens when the community rejects? Where do these couples go? And a very, like whenever we have seen the subject of elopement or runaway couples in general, or interfaith marriages or intercaste alliances, we have seen that popular culture has a certain romanticized image of runaway marriage and subject of elopement. Right. So if we look at movies like Bhutnath, Mirzapur, Love Hostel, or Ishaqzade, they have shown that there are these two heterosexual individual couples who are coming together to get married. In Ishaqzade, you see the role of traditional authorities like Khap Panchayats. While if we see Love Hostel, which is more like a contemporary movie, it has been around shelter homes and the lack of shelter homes for runaway couples. But if we look at movies like Mirzapur, you see a very small scene of two individual couples registering themselves in a very Sarkari office. That's the image that we have of registration, right? That's the image we have of the state. So that became my entry point to sort of understand the state. Where is the state? That became a question for me, that, okay, in all these cases, community is sort of against these interfaith alliances or intercaste alliances. But what is happening with the state? What is the next step? Where are these couples going? So popular imagination has sort of indicated that, just popular imagination has sort of indicated that violating caste-based sanctions or religious sanctions is something very romantic and out of the world realm, and we, sort of look at it from a very romanticized perspective. And never ever the state is depicted in these equations. So that became my entry point to understand, runaway marriages or interfaith alliances. And even in popular culture, even in the public discourse, we have couples like Swara Bhaskar and Fahad Ahmed as this interfaith couple who met during the CANRC protest, and then they used Special Marriage Act to get registered. And if you have seen their marriage, like everybody was dancing, and there's a whole reel on how they went dancing around in the Sarkari office, registrar's office also, and then they solemnized their marriage. But these are the cases which are the more fancier versions of the subject of elopement. But there are case studies of couples who die by suicide, or if to say so, they are honor killings. How do we understand these two cases where couples die by suicide, or they are hounded by community and there are community attacks? And where is the state in all of this? Is the state speaking the language of the community? Where is the subject of honor embedded in the law? So that became a very interesting sort of comparison for me to look at in the whole subject of interfaith alliances. And so I would like to, throw this question at the audience, that how do we define interfaith love for the state? What is interfaith love for the state? How are we visualizing that for the state? Where is it situated? And where is state situated in the journey of interfaith couples, interfaith runaway couples? Okay, one is that, and how is the subject of runaway marriages or interfaith love, interfaith runaway marriage is located in the state discourses. So to say, state databases, that census will never pick on couples who are eloping and register them as eloping couples, and take their data as, okay, this is their family and all of that. They rely on very heteronormative format of recording that kind of data. So where do we find these couples? That was a question, and that is still a question for me, that how is state locating, where is the state locating these runaway couples? Where do we find them in the data sets? Where do we find them in the state archives? So that is something that I am still sort of dealing with here in this, talk. But when we look at the literature, it talks about the need of the state. Whenever we see, couples like, couples who are in live-in relationships, or couples who are, cohabiting together, there is a constant desire from their end that you will feel that they want to legitimize their relationship. They want to have someone to approve that relationship, and for that the need of the state has been considered pivotal. So if we look at the literature so far, for example, work that we for example Parvez Modi is one of the, has produced one of the pioneering work on civil marriages, and she also argues that civil marriage is more difficult to solemnize when it comes to comparing it with, say, Hindu marriage. So, in all of these cases, Modi argues that these couples are not community people. They are the people who have sort of become, a symbol of unencumbered self, have a certain kind of individual belonging. And, Modi's case study or ethnography is more about, Tisazari family codes. Where she's arguing that like post-colonial state legitimates what community is rejecting. So, if community is rejecting a certain intercaste alliance, post-colonial state would legitimize that in certain ways. And how that happens, that maybe is happening through the language of the way state agents are working, the way you see their mindsets and prejudices being imposed onto these couples. Very interestingly, Rama Srinivasan is not looking at state in that sense. Srinivasan obviously talks about different kind of traditional authorities when it comes to the registration of these couples, eloping couples, and the courtship period and all of that. But Srinivasan says for these couples, state is an aspirational space, a space to sort of register their desires, a space of refuge, a space of finding comfort and safety. But is state that? That's what we will, be questioning in this talk. She says that there's this element of apni marzi karna, an element of love, a choice that is there when it comes to these couples who are, couples who are eloping, or who have a certain lack of parental consent or lack of community consent to, go ahead with their alliance. But why is marriage important? Like that's the question. When, in any kind of relationship and in any kind of partnership, why is marriage important? So Nancy Scott might have an answer for that. It's because marriage is helping you have some kind of privileges also at the same time. Because state, marriage is a favorable thing. Your rental benefits are often distributed. Your insurance gets better. So there are so many benefits that marriage provides you, and this is the reason a lot of couples would actually want to legitimize their bond through marriage. When we look at, say, more feminist works, like say Veena Das's work on in critical events, talks about that how women carry the symbols of nationhood. So she is, discussing ethnography of during the partition, that how women were abducted during that timeline, and reinstating back to their communities, reinstating these women back to their communities. So if they were abducted, it became very important for them to be sent back to their homes and families in Pakistan or vice versa, so that, their kinship and nationhood networks could be kept intact. So in that manner, we see that even for these adult women who are registering themselves, who are making this choice, I think the idea of a certain kind of religious nationalism becomes very important, and the idea of agency is often diminished when it comes to the, subjects of honor and community honor. And it's important to keep the honor intact, and for that reason, the idea was to, so Vinadas argument is that it's not that these women could not have been, made a part of whatever families they became a part of later on, and, they could not have been reinstated in the families they came to be a part of after partition. But it was very important, and committees were constituted so that they can be sent back and reinstated back to their communities, so that the honor can be kept intact. So in that lens, from that perspective, I mean, law is also working in that way. This post-colonial state is also working in that way, where it wants to restore the idea of nationhood. And nationhood will vary from community to community, what that community is imagining about that particular idea of nationalism. And for that reason, the idea of interfaith alliance becomes a very, not to say revolutionary one, but a rebellious one for the state, because it actually questions these idea of nationalism. If we look at from feminist theoretical, framework of the state. Now, there are anthropological works also by, say, scholars like Donner and Santos, who have talked about the role of globalization, that how this idea of love marriage is can be seen, in alliance with something like globalizing age, emergence of new middle class, but also the fact that Hindu customs and Muslim customs are again enshrined as their personal laws, and they became fixed definitions of communal belonging. That if you are registering yourself in a Hindu marriage act, that's how, going ahead, your marriage would look like. Your children would be raised, and that's how your familial division of labor will also happen. That's how personal laws work. Then comes the Special Marriage Act. Special Marriage Act is this third act, which is really pedestalized for its, revolutionary secular impulse that it inserted in the post-colonial India, according to Rochana Majumdar. And then Tahir Mahmood's work tells you that, it's a space of individual belonging. That's what Special Marriage Act allows you to do. But then when you like see Special Marriage Act, it has often been criticized for looking like Hindu Marriages Act as well, by scholars like Patricia Oberoi, who say, especially like provisions like Section 4 of the Act talks about prohibited degrees of relationship, that you cannot get married within your cousins, within your relatives, unless, which was amended later, that unless one of the parties' custom allows for that. So, Special Marriage Act, it's very interesting how there are controversies attached to this act. One is, its notice period, which is of 30-day notice period. There was a petition that was filed in some time ago when I was writing my PhD, and it was squashed by the courts. It was never taken up, but it is a controversial act in the sense that how far the act has enabled couples to exercise their agency is very, very important, and especially in cases of interfaith marriages. So, what happens in interfaith marriages? It's very interesting for me to see here that okay, I'll come to that later, but first let me just like talk about a little bit criminalization of the law also here. Just like Srinivas and Rohit Dey's work is very popular, and recently also there's a book that has come by, that has been released by they. Another book, which is a People's Constitution, is very, very important work when we look at how he's talking about Constitution. He talks about Constitution as this emancipatory space. So just like Srinivasan, though they is looking at state as this emancipatory space also. More specifically, he's looking at constitution like that the constitution is filling that space of emancipation for those who are facing violence. So it's filling that space between the promise of the law and the reality of violence. Now, where is the violence? The question that we'll ask is, is state being violent? Well, there are direct acts of violence that we know of honor killings, and not just that, of many other kinds of killings that happen. But there are violent acts in the way law is working also. And that's why this talk is titled like that, in the way the law is implicitly violent. So the criminalization is embedded in the way law is functioning. Uma Chakravarti's work talks about that criminalization. That, one of the provision of the special marriage act is like that, you have to, after the two individuals file for their details under the special marriage act, their details would be displayed on a public notice board. So displaying that on a public notice board is obviously, there are questions related to privacy, but often what happens, these notices are spotted by people, by acquaintances of the girl's family, who are then later told that your daughter is planning to elope, so you see what you need to do. Often these people have, they belong to a certain right wing organization, and these cases are obviously more popular in certain states as compared to other. And we'll come to that how special marriage act is also working differently across different states within India. So word of the law might be something else, but there are conventions attached, conventions that are being implemented, which are those are some whimsical beliefs that we see that they are coming to manifest. So state apparently, idealistically, to begin with, is this rescue space, is the space where, couples can exercise their right to love. It's also a space where Hannah Arendt would say that private interests assume a public meaning. But is it becoming that? That's a question to sort of look at. Now, Special Marriage Act, I was trying to come to this part, that Special Marriage Act is mainly used by interfaith couples when the act was very well made for the cross cultural alliances as well. So usually the intercaste couples, you will not find them using this act that much as compared to the interfaith couples, because a lot of times we assume that the act is made for interfaith couples, and this is something that is that is very important way of looking at the way this act is being implemented right now. The problem is, now the question is why? Why only interfaith couples are using it? Why interfaith couples tend to be more aware about it sometimes? Or even if they are not using it, interfaith couples, then what do they do? What happens, whatever they do then? Obviously, then the method to go ahead with the marriage would be ritualistic marriage. Then what are the consequences of that ritualistic marriage is something we'll understand. Now, there are certain misgivings of the Act. One is I have talked about Section 4, which disallows prohibited degrees of relationships. Another is counterfeit certificates. So I raised a question that what happens when these interfaith couples are not using Special Marriage Act? Obviously, what they'll do, they might go to a lawyer. A lawyer might tell them, I will convert both of you, and after the conversion, you'll be given a certificate, and that legitimizes your relationship. You are married then. So a lot of times, because of fear, because of the 30-day notice period, they're like, oh my God, there is this continuous anxiety that I'll be facing from family and community members. And if you have eloped, anyway, the anxiety multiplies. So what Shalini Grover's ethnography of Mohini Nagar tells you that a lot of times these obviously there is no conversion certificate like that. If any one of you is planning to use Special Marriages Act, there is no conversion certificate. There's no certificate like that. So a point in awareness is this: they are many times handed over counterfeit certificates. They do not work. Arya Samaj Mandir's issued certificates do not work. They have been classified as, not legal documents for the courts unless you go to the court and register your marriage. So, either under Hindu Marriage Act or under your personal law, Delhi has recently come up with compulsory order to register your marriage. So, I don't think it also is like Hindu Marriage Act. So, only way to register your interfaith alliance is through Special Marriage Act. So I want to actually promote Special Marriage Act also, because the meaning has been manipulated because of certain, say guardians of the law and the way the state is working. Now, criminalization is also taking place through this, a lot of times what happens in cases of runaway marriages and alliances and interfaith alliances, especially habeas corpus is used by the family members of the girl, claiming that she is minor, or and because she's minor, her consent becomes invalid, and parents, and so to say fathers specifically, can use that consent for the minor. So bone ossification tests happen. This has been there throughout literature. You'll see Chaudhary's work has talked about this. Prem Chaudhary's work. Bone ossification test is very, very, they'll do some tests. They'll identify the age of your bones and see how manipulated this information can be. So just based on this information, a lot of times it is assumed that the woman who came to register was a minor, was not of age to exercise her will. And these kind of uses of law, these are the ways state is working. These are the ways the law is working. I mean, we'll talk about community later, but this is the way state is sort of borrowing from community. So how do we really understand, that whether state is an emancipatory space or not, what Day is talking about, or the way Srinivasan is assuming that for couples, this is an aspirational zone. For couples, state is an aspirational zone. Is it? So that is something that we need to sort of understand. Now, how do we define state? Now, all throughout my PhD, the process of defining state became very complicated. I started with an understanding where I would look at state more from the framework of institutional lens. Then I understood that how institutional institutions are also hallmarks of our culture. And this is why when we look at, and this is what maybe more or less literature also trying to say, that, if you look at Chaudhary's, Modi's work, Chakravarti's work, they say that state is perpetuating what community is believing somewhere, and law becomes integrated into the social relations. Usually we have seen that, we think of law in a very dichotomous way, that either this law will punish or it will emancipate, it will rescue, it will give freedom. But this is not what Kapoor and Kosman say. They argue that law is very, there are subversive sides of law, and there are competing visions of the way law functions. So you cannot look at law from dichotomous vision. And law is working in multifarious ways. And one manifestation of that law is love jihad. We do not have a law on love jihad as yet, but many laws are being used to frame them into sort of a love jihad fashion. Now, are there any shelter homes to protect interfaith marriages? I mean, Love Hostel fails to capture the subject of shelter homes, but Chakri Vahini versus Union of India is a very popular Supreme Court judgment, one landmark judgment that came up with this provision that shelter homes need to be constituted. Now, in Pratiksha Bakshi's study, what we find that a lot of times when habeas corpus is used for these couples, a lot of women minors are then sent to places where the survivors of domestic violence are living. So shelter homes do not even exist. And these, survivor homes are in such a bad condition. And there are a lot of like studies on that as well. So law and state for me, just to begin, like just to like draw it here, are very heterogeneous in essence, and institution of state are also not monolithic. When we look at the judgment of, say, Hadia by the Kerala High Court and compare it with the Supreme Court, it's very different. Hadia is called as vulnerable as a subject of conversion by the Kerala High Court, while the Supreme Court says we cannot be parents patria to an adult woman who is capable of making her decisions. And they quash the term love jihad. Implicitly, they use the term conversion, not love Jihad. It was used in 2009. So, so are you saying within India, each state might respond differently to interfaith marriages? Yes, that is a possibility here. Migration tells us now the problem is that because not a lot of couples are using special marriage act, especially not other cross culture in a lot of other cross cultural alliances. Usually, it is being used in interfaith cases. Now, in the cases where couples cannot use it, but they are aware that here the Special Marriage Act is not being implemented properly, they often migrate. And migration data tells us that 87% women migrate for marriage. Now, there could be data also has its politics, and we can look at Manisha's work for that. But this is one way of understanding. While it's the reverse for men who are migrating, they might be migrating for employment opportunities. So in this study also, in my study also, I could see that couples are migrating to safer states, and it is a visible trend, maybe based on the way bureaucracy is functioning. Although law is the same across states, it has to function in the same way, but bureaucracy is working in different ways across states. That's what we could, I could see. That's what one could see. In a more contemporary way, we see that there is anti-conversion legislations that have been enacted throughout different states like UP, Uttarakhand, where there has been controversy around implementing uniform civil code, regulating live-in relationships, and in states like Madhya Pradesh, Haryana, and Rajasthan as well. So there might not be, as I saw, law on love jihad, but existing law is often framed and used against young couples exercising their right to love. The interesting part is that for under these anti-conversion legislations, the conviction rates are very low. Eventually they might arrest someone based on the doubt, okay, this person has converted this girl, and this girl is so gullible to not use her own agency and all of that. But then again, nobody is convicted. So there are several reports to tell you that, but I don't think state has come up with a separate database as yet. I think we would have that once NCRB comes with the recent statistics. Now, what is Love Jihad? I mean, it's a mythic campaign according to Charu Gupta. Scholars like Charu Gupta argue that it's an emotive, fabricated political fantasy that we started seeing like sort of manifesting or maybe worded during 2014 electoral campaigns. But it has resemblance with, say, Shuddhikaran movements of the 20th century, which were done by various right-wing organizations. First time where did the state use this word was when Kerala High Court used the word in 2009. Now, love jihad, we might think it's something only, the majoritarian politics is sort of talking about, or a certain political party has only, called out for this kind of campaign. No, it is very much a part of state discourse. Now, what I understand is state discourse cannot be sort of separated from this kind of parochial belief system that might be coming from a certain mindset, something, a certain political party, certain political thought also, right? Then are we trying to say that the state is complicit in the acts of community that argues that acts of love could be acts of manipulation or conversion? So is the state becoming complicit? That's the larger question for us to sort of look at. Another thing is ideology of party politics or Hindu nationalism cannot be seen in isolation. Just like I said, it's a continuum. Community and state is a two-way road, which is what, each one is speaking the language of the other. So are you telling me it's a hopeless story then? Maybe, the answer is not going to be that linear for social scientists ever, I feel. However, the state's engagement with interfaith marriage, the operating framework of which is guided by parochial belief systems, we do know that, debates of conversion or ghar wapsi have become very popular these days. And those are some kind of debates that are in interaction with these, in the way these couples interact with the state. It affects their interaction. Besides that, if they are aware, educated, if they are actually dealing with some, say, NGO, then they are more aware to sort of navigate their course. Criminalization of couples through law is not something new. Different states have used modus operandi of using social and legal methods, such as lawyers manipulating clients through counterfeit certificates. There are many other ways of manipulation also that one can see if one looks at literature. Also, a lot of times the kidnapping and abduction data of women is misconstrued as the data on elopement. So that is something that Nitika Vishwanath has found in her study on shifting discourse of rape, where she says that she conducts this, focus group discussion where she's found out that a number of these cases were not cases of, say rape, but they were cases of runaway marriages, and runaway marriages dealing with the minors maybe, but there was essentially some kind of consent involved, but they were not cases of rape. And there is a lot of difference. There's a lot of difference when we look at two. Right. So theorizing state when it comes to its engagement with the subject of interfaith marriage is marred with tensions and conflicts arising from communal forces in the recent times that we have seen. So this is all that is, and I hope I have been, I was able to make you think, make your brain sort of your gray cells, rack into that direction. Yeah.
Thank you so much, Dr. Chachra. That was a very enlightening presentation. You introduced us to a lot of scholars that, at least for me, I was not acquainted with. So it was really enlightening and stimulating for us. Now I invite Saumya to take over with her presentation. Thank you.
Are you able to see the presentation?
Yes, yes.
Okay. Can I ask whoever is that has the controls to turn my camera off if I start to like break off because my internet's not so great.
Sure, sure. No worries.
If I realize that's happening. Okay. Thank you to the Dark team for putting this discussion together and for inviting me. Work right now. I'm only 2 months in, so I don't have any concrete findings that I feel comfortable sharing at the moment. What I'm going to do in this presentation is take a step back and turn the focus of my talk to what one might call the doctrine of law. So what I'm help us think about is uh, what is the law of marriage-related religious conversion, and how these anti-conversion laws have shifted, changed, or disrupted what came before them. I'm hoping to encourage some conversation around how we can situate the experiences of inter-religious marriage making within this changing, but in some ways, continuing legal framework, like Dr. Chachra mentioned. So I have about 20 minutes. In the first 10, I'll establish some links between the most recent wave of anti-conversion laws and interreligious marriage making. What do these laws say about marriage and how might they affect the process of interreligious marriage making? Then in the remaining 10 minutes, I will offer 4 snapshots from laws loosely understood, statute, case law, policy reports that preceded the love jihad legislation. And finally, I'll pose some questions that emerge from juxtaposing these snapshots of law against the assumed impact of love jihad laws on interfaith marriage making. So the basics first. There are 2 modes of marrying under Indian personal law, under the broad legal framework of law of marriage and divorce. One mode is the personal law mode, and the other is the Special Marriage Act. Under the personal law, for example, under the Hindu Marriage Act or under Muslim law or Christian law, the applicability of a personal law depends upon an individual's religious identity, which means that marrying as per this mode is very difficult for 2 people who don't belong to the same religious identity. For example, the Hindu Marriage Act will say that it's applicable only to Hindus, and the term Hindu is defined to include Hindus, Sikhs, Jains, Buddhists, Two Hindus or a Hindu person and a Sikh person may be able to marry under the Hindu Marriage Act, but a Hindu and a Muslim can't marry under this law. Marrying under the personal law also involves religious ceremonial marriage, rituals such as the Saptapadi in some Hindu marriages, or the nikah, which involves an offer and an acceptance, and meher under Muslim law. The other mode of marrying is through the Special Marriage Act of 1954. The Act provides for what is called a civil marriage, which is also sometimes referred to as a court marriage. In this civil marriage, the bride and the bridegroom need not go through any religious rituals to marry. Instead, it's, as Dr. Chachra mentioned, seen as a secular marriage formalization ritual, which is officiated by the state. So a state functionary, the subdivisional magistrate in Delhi, could be somebody else in other states, is in charge of officiating the marriage, of administering an oath to the couple, where the couple will say to each other, I, so and so, take you, so and so, as my lawfully wedded husband/wife. They will sign some papers in the presence of 3 witnesses who will also sign some papers, and they'll get a certificate. So the personal law marriage takes a few hours. If you go to an Arya Samaj mandir, it may take 45 minutes to an hour. The Special Marriage Act, on the other hand, takes at least 1 month, statutorily up to 3 months. Sometimes it can take more, depending upon the kind of marriage officer and the SDM office one is dealing with. So, unlike the personal law process, the SMA process is very lengthy. It compromises the couple's safety through public notice requirements. Naturally, then most couples try to find ways to marry under the personal law. For an interfaith couple, it is possible only if one person converts and switches the personal law applicable to them and becomes part of the personal law regime of their partner. So this is where the anti-conversion law comes in. Since 2018, many Indian states have enacted laws to make marriage-related religious conversion invalid and a criminal offense. These laws build upon existing anti-conversion legislation, as you can see on this timeline. The earliest part of the timeline, and we've had spurts of interest across different states in legislating on anti-conversion laws, usually in response to the stated problem of mass conversions. Since 2017, we've seen a spurt in this kind of legislation, and all the legislations that have come since 2018, the most recent one, which is also not on the chart, is in Rajasthan, which was enacted last month. They have some very unique, you see, Section 3 of the Haryana Prevention of Unlawful Conversion of Religion Act. Like similar, sometimes identical acts passed in Uttarakhand, Himachal Pradesh, Uttar Pradesh, Madhya Pradesh, and Gujarat before this, and in Karnataka and Rajasthan.
I think Saumya's network
Uh,
has
yeah,
died down.
yeah,
She's left the meeting.
same. I am not, yeah, maybe she should be connected. I'm unable to hear.
Am I audible?
Yes, yes.
Sorry
Yes.
about that. Can you tell me when I lost you?
Haryana,
The newest
Haryana code.
legislation, 2000,
Yes,
1 month ago.
that's when yeah,
So we've come to this slide, which is Section 3 of the Haryana Act. Is this visible to everybody?
yes,
Yes.
yes,
So, like similar acts that have come before this act in other states, afterwards in Karnataka and Rajasthan, this act prohibits marriage-related conversion
and declares any marriage that is solemnized after a conversion void. No person shall convert or attempt to convert either directly or otherwise or for marriage. Now, we don't know what this conversion by marriage means. Conversion for marriage is the kind of conversion that I'm speaking about. And Section 5 says any marriage solemnized in contravention of Clause C of Section 3 shall be null and void. Clause C says conceal his religion with intention to marry. So no person shall conceal his religion with intention to marry. Now these statutes have come to be called love jihad laws because they legitimize the conspiracy theory. We've seen a lot of literature come out in the past 4 years which analyzes the narrative elements of these. Take from the love jihad conspiracy theory, as you can see, Section 3C does that. For example, a lot of these songs and news reports that you see online these days will tell you that somebody changed their name to Rahul or Sonu to entrap the girl into marriage, and that is exactly what the legislation is also talking about. It accepts the conspiracy theory as fact, as a problem that needs remedy, and offers a solution in the law for it. So many of these acts and the rules legislated under them provide elaborate procedures for converting in a lawful way. And if these procedures are not followed, then that conversion becomes unlawful. Some will require advance notice of religious conversion to the district magistrate. Some will require you to ask permission for converting, and the district will give yes, and then you may convert. Then after you've converted, you and the person who's officially
I can't hear Saumya. Can you?
No.
Saumya, we've lost you again. We request the participants to hold on to hopefully for a few seconds. I think Saumya should be back right now.
so I'm not sure why this is happening.
Hello?
It's okay.
Yes, Saumya, you're audible now.
Let's just blame state for it. Let's just say some state conspiracy so that we don't talk about this stuff. It's fine. Continue,
Saumya,
Saumya.
I'm very sorry about this.
If it's taking too much bandwidth to share the presentation and speak, maybe you could then not share the presentation and just share your ideas, because then you'll probably be
I
better.
can do that. I can do that. Yeah. Okay. Let's hope this works. Okay. So now we see that a lot of scholars, the literature that is coming out about these acts is signaling a problem about interfaith marriage making. There's a tendency to speak about how difficult interfaith marriage making has become now that there are anti-conversion laws in place. And we'll put this argument, which is becoming increasingly popular in scholarly and popular writing. We'll put a pin on it and go through some snapshots of laws like I mentioned earlier. The first one, now I had slides for this, so I'm just going to speak about them.
The first law that I want to take your attention to is the Dissolution of Muslim Marriages Act, which was enacted in 1939. Now, Section 4 of this act says that if a woman converts to Islam to marry a Muslim man and then reconverts to Hinduism, then the reconversion will result in an automatic dissolution of her marriage. Now, the Dissolution of Muslim Marriages Act, very interestingly, was passed to, for the first time, give any group of women in India the right to divorce under statutorily stated grounds of divorce. And those statutorily stated grounds of divorce were provided to prevent Muslim women from converting to dissolve their marriage and escape bad marriages. So this Section 4 and its exception, which says that if a Hindu woman converts and then reconverts to Hinduism, her marriage becomes void, was in fact included in the DMMA to in response to the objections of Hindu legislators to intermarriage. And this is happening in 1939. Rohit Dey's early work, published in 2009, historicizes the DMMA. And he draws from Charu Gupta's work that Dr. Chachra mentioned. And the kind of objections that Hindu legislators raised to intermarriage at this time drew from the Shuddhi and Sangathan discourses that began in the 1920s. So this is one law that we can keep in mind. The second law are the twin judgments of Sarla Mudgal versus Union of India and Lily Thomas versus Union of India. Now, if you've heard about these twin judgments, it's probably in the context of the very distasteful remarks made by the Supreme Court in both judgments about the plurality of personal law and the need for a uniform civil code. And that is the context in which these judgments are usually written about. Both cases arose from sets of petitions filed by Hindu women whose husbands had converted to Islam to marry again because Muslim personal law allowed polygamy and it was criminalized under Hindu law. So they used this jurisdictional plurality to do some jurisdiction shopping and switch personal law to take benefit of their new personal law. Now, in both the cases, the court makes some comments about what a valid religious conversion is. It says if, in Lily Thomas, if a person feigns to have adopted another religion just for some worldly gain or benefit, here the worldly gain or benefit is the bigamous marriage, it would be considered religious bigotry. It also asks the state to enact laws to regulate marriage-related religious conversion. So very clearly, the court in Sarla Mudgal is asking the state to set up a committee and create a law for deterring such conversions. Now, the third quote-unquote law that one can think about is a Law Commission report which came out in 2010 in response to the Kerala High Court's discomfort with dealing with interfaith marriages involving a couple called Betsy and Sadhanand. This was a Christian and a Hindu couple. And the court had trouble determining what their child's religious identity was going to be, or whether the child was legitimate or not, and said to the Law Commission that please tell us what to do in such cases. So the Law Commission suggested regulation of marriage-related conversion through executive directions, especially in states where there was no anti-conversion law. And this is before the love jihad laws came in. These recommendations seem to want to put a process in place which can be used by citizens voluntarily to make official their religious conversion, where they can go to a state official to ask for its registration, much like the registration of a birth or death or a marriage. And the last and final law that I'd like you to think about is the direction of the High Court of Rajasthan in a case called Chirag Singhvi versus State of Rajasthan, which came out in 2017. In this case, the petitioner's sister eloped with a Muslim man, and the petitioner went to court saying she was being illegally detained by her partner. Finally, the court allowed them to be, saying there was no illegal detention and she's an adult and she can do whatever she wants, while simultaneously also suggesting making some directions about regulating religious conversion related to marriage. And these and in the words of the court, these directions were intended to remedy the problem of forcible conversion of women to the religion of the minority community. Now, these directions are notably stricter than those of the Law Commission of India, which came out in 2010, and demand that the state ensure that every converting individual has theological knowledge of and faith and belief in the religion that they are converting to. Now, I want to leave you with these 4 snapshots and perhaps think together through some of the questions that emerge from looking at the anti-conversion legislation that has come in recent times against these 4 laws that have come before. There are 3 broad questions that I'd like to pose. How do these new statutes depart from pre-existing legal governance of marriage-related religious conversion? What has changed, and how do anxieties about marriage-related conversion take on new life in new legislation? How can these continuities be conceptualized to better understand what has changed? And more importantly, how can we situate the experiences of interreligious marriage making within this changing, yet in some ways continuing legal framework? How can we understand the changes in the experiences of interfaith marriage making and the relationship of these ostensible changes with the law? That's all for me. Sorry about the trouble with the internet. I hope you got most of it.
That's okay, Saumya. Maybe later you could share the presentation in the chat box and we'll share it with our
Yeah, I'll do that.
participants.
Yeah.
But
Thank you so
we
much
also,
for sharing.
but we also got most of it.
Yes, we
Okay,
understood. We
thank you.
could hear you were audible. Don't worry.
Yeah.
Uh, Thank you so much. Now I invite Saumya to share her thoughts, ideas, questions that she may have. So, and I'm so sorry, Khushbu. I'm so sorry. I'm so sorry.
Hi, am I audible?
Yes, you're
Yes.
clearly audible.
Okay, if that's okay, can I keep my camera off because there seems to be some problem with my laptop camera. So,
No
that's
worries.
okay. Yeah. So first of all, thank you for the invitation to be a discussant for this wonderful set of presentations. So I do not specifically work around interfaith marriages, and I largely look at Hindu intercaste marriages, but I am deeply interested in understanding the politics around contentious marriages, and that's why I have some thoughts on the 2 presentations that were put before. So first of all, I would like to talk a bit about and this was a point that was touched upon by both the speakers, that is about this contradictory and contested life of the Special Marriages Act. So it has always been a contested, law, even before independence, when it used to exist in the form of Act 3 of 1872. And then it, became the Special Marriages Act, the Civil Marriage Law. And this contestation also arises from, as Manisha said, of this mistaking the Special Marriage Act to be a law that only enables marriages across religions, and that is not true. And I also want to, bring in this anecdote to my own field work, as to how not even the general community and people who go to marry to these, sarkari offices are, confused about it, but also the state functionaries themselves are not very clear about the historical origins and the, the sections of the Special Marriages Act themselves. So when for my particular field, I work, in Haryana on the intercaste marriages, and there I was conducting a focus group discussion, and one of the participants told me that he is a Hindu Jat by caste, and he married his wife, who was from the scheduled caste community in Haryana itself. And they said that we are atheists and we do not wanted to get our marriage registered under the Hindu Marriage Act. So they went to the concerned authority in their respective district in Haryana, and then they were denied the registration under Special Marriages Act, saying that only interfaith couples are allowed to register their marriage under the Special Marriage Act. So this this very weird fogginess that is created around this act through these popular narratives and also rumors and disinformation is something that we need to think about. And from there, I proceed to this another point that is about criminalization of these marriages. So this was also pointed out that this criminalization is not new. Yeah, that's true. But also we need to see as to how what has changed after coming up of these anti-conversion laws that criminalizes and targets specifically the religious conversions for the purposes of marriage. So one of the articles that I remember, I think, was shared by Saumya, and there was some discussion. It was by Sharma and Jenkins, and there was some discussion on how the disinformation, the conspiracy theory called love jihad, has been folded into the state law itself. So it has become a part of state law. And as during her presentation, also Soumya talked a bit about this clause C of the section 3 of the Haryana law, I guess. And so something that used to be a part of popular culture to, films like, Kashmir Files, Kerala files, etc., that has become, and that is increasingly becoming a part of everyday functioning of the state and a functioning of the law. And so we also need to deconstruct this larger category of interfaith marriages itself. So whenever we talk of interfaith marriages, it's just that we are thinking about the conspiracy of the love jihad and Hindu men and Muslim men and Hindu women. But when we also need to take a comparative look as to how state is behaving in cases where the situation is vice versa. So if a Muslim woman wants to marry a Hindu man, how does the state perceive these cases, and what is the what is the what are the ways in which the state functionaries and their individual personhoods, as Srinivasan calls it, come into play. So we can actually draw a stark contrast between these this criminalization and resentment around Hindu-Muslim marriages when the man is a Muslim, versus there is this another idea of ghar wapsi, right? So if a Muslim woman is marrying a Hindu man, then it becomes a point of celebration, and that is perhaps welcomed as seen as quite progressive. Uh, uh, so that's another thing. And the third thing that I also want to talk about is what happens after marriage. So, because there is so much religious polarization in the public sphere, in the politics, and the state functioning, so there might be cases where the families in the community probably accept the marriage because of certain compulsions. Maybe the son is the only earning, only breadwinner in the family, and they have no choice but to accept the union. Then what happens? Imagine in the de facto Hindu state that we are probably living in, and this is not me, there are scholars who are saying that. So then, how would post-marital or maybe post-wedding life of a Muslim woman turn out to be in a Hindu household or a Hindu, neighborhood after she gets married to such a law, and vice versa also. So and to this also brings me to another interesting point as to, because the Indian state it has always had a protectionist approach when it comes to dealing with the desires and love and marital choices of women. But in recent years, we have seen how it has also adopted an aggressively protectionist discourse through enactment of, or maybe criminalization of uh, you know, Muslim practices, Islamic practices like maybe triple talaq, right? So it claims that it's protecting Muslim women from Muslim men. But then what happens if after a special marriage act in which a Hindu man is married to a Muslim woman and there is a marital conflict, or maybe there are cases of domestic violence, then how does that particular state enacts that kind of protectionist discourse towards a Muslim women, will they say that okay, uh, okay, probably it's your fault? So what will be those kind of state narratives when your Muslim woman is then in a interfaith marriage with the Hindu man? And if we flip the situation, if a Hindu woman is in an interfaith religion with a relationship with a Muslim man, so this criminalization of the Muslim man as the seducer, as the deceiver who lures, women into this trap of, getting trap of love and then getting married and then doing all sorts of nasty things. This is also something that needs to be dissected after what happens when people get married, because state then is, so we often assume, so as I've seen in the, not so much in the presentations because we do not have much time, but in the popular literature and the dominant literature around the this issue as well, is that the role of the state is interrogated only till the point, till the point where the marriage gets solemnized and registered. But then how does state responds to situations of domestic abuse, domestic violence, maybe questions of marital conflicts and questions of separation after these marriages get registered? So that is also something, and that my hunch is that it would be very qualitatively different from what happens in caste endogamous and religious endogamous marriages. So yeah, these were a few comments from my side. uh yeah, thank you.
Thank you so much, Khushbu, for your insight. Now we can move on to any questions that the participants or even the discussant might themselves have, so our speakers can answer them. Questions can also be noted down in the chat box. You're not very audible.
Is it better now?
Yes, yes, yes.
I'm very sorry. Yeah, I'm saying that perhaps Khushbu, as a discussant, has raised some concerns. Maybe the speakers could respond to that, and then we could also take a second round of questions.
So I'll just go ahead with the contention that she raised about like what happens when Muslim women uh, are married into Hindu households. I completely agree. It is looked at as cases of ghar wapsi. It is homecoming, and the responses of various state agents has been in that direction. And I don't want to obviously talk a lot about this because this is still under, this work is still developing, and I am also like publishing this. So that's why I didn't go too much into the direction of my findings also. Another thing, that what happens post marriage. Again, same answer to that. Yes, there are a lot of contradictions and contestations as to what happens after marriage also. There could be cases of marriage does not work. Just because SMA is solemnizing a marriage, just because there is a secular impulse behind it, about which a couples might not even have that kind of academic understanding as we have. One is that. Second, not being used by intercaste couples. I mean, I'm sure Ambedkar is very disappointed with this, but it is not being used as much by intercaste couples. And the same Brahmanical procedures are usually used to solemnize in intercaste alliances as well. So even in those cases, marriage is marriage, right? I mean, to just to like for feminist scholars, marriage in law, is essentially working according to a very patriarchal, in a very patriarchal manner, and that division of labor, not just that, in the way law is enshrined, in the way law is interpreted, that all of that in essence is like a male. So it is obviously an oppressive structure. That, having said that, I think what needs to be sort of looked at is how like the conversation was more about how these marriages are solemnized and what are the struggles during the solemnization and what does literature say about it. But for sure, that the conversation that Khushbu is bringing here, I think it's valid, and hopefully if this work gets published, I will have a chapter on what happens post-marriage. So yeah, I mean, this is an ongoing chat, I believe. Thank you.
Nice plug, nice plug. So we have to come back again for another Baithak when this work is published. Got it.
Saumya, do you want to say something?
Yeah, I also found the last bit of Khushbu's comments very provocative. How would the state respond to marital conflict after it is solemnized? I think from the kind of archives that I've been able to put together, it does seem that now what the judgment tells us is not really what really happens in court and what the court really cares about and all of that, right? It's one way of resolving a dispute for the judge. But from what I see in interfaith marriage disputes that go to a family court or eventually as divorce cases or annulment cases, often the question of religious identity is a low-hanging fruit that allows the judge to resolve the dispute and nullify the marriage, right? So that is something that one could consider as like a potential area of research where when thinking about what happens after the marriage, if one would look at legal archives and start there. But I also think that something like following couples at the time of marriage and after marriage, especially, and finding couples where that kind of conflict has arisen would be very, very challenging for any researcher. I imagine it would take a very long time for that kind of work to come out, where a conflict arises and that conflict results in approaching courts for resolution. Yeah, there's a recent, I don't know how recent, maybe 2022 article by Gopika Solanki, which talks about the constitution of interreligious marriages as intra-religious on paper, which is something that Dr. Chachra mentioned. I mentioned that converting and marrying is a very, very normal thing, including in communities where intra-religious but intra-caste marriages are normal, are customary, are arranged. There, converting and marrying happens very often. So finding that kind of archive where does one locate interreligious marriage in state records, in legal archives, is challenging in itself.
Thank you, Saumya. Now, if Khushbu, if you have any second round of follow-ups or any follow-ups about what the speaker said, we can go for that, or otherwise participants can ask questions.
No, I think that was sort of a, exercise in thought that I was just putting forward, some of the shortcomings that I was also seeing in the existing literature. But as Manisha also told me that, her upcoming work will be talking about some of these issues. So I'm quite fascinated and also anticipating, reading work. So yeah.
Thank you so much. Jigyasa, you raised your hand.
Thank you so much. I have two quick questions. The first one is, and it's open to everybody, including the discussant, because it seems all of you are working in the same area. Of course, there are differences, but broadly speaking, to me, when I'm hearing you people say that there's a certain way in which law, when it's interacting with intimacy, that is personal in nature, which is to say that usually law comes in when there is conflict, when it comes to marriages which are outside of SMA, right? So two people can go ahead, call 200 people, get married, have that happy marriage, and go on to die at their respective times because everybody has to die, but never ever have to face the court of law when it comes to their love or their intimacy or their marriage. So essentially what's happening here is that when there is an interfaith couple, you have to encounter state to begin with. So the conflict, as far as law is concerned, is implicit and out there from day one. Where in personal wherein personal laws, which is religious personal laws, there's a certain way in which you are kind of not interacting with the state unless there is a conflict. So when there is a conflict, would you then go to code of law, which is what I'm hearing, and whatever I know about. So is there a relationship between conflict in this case between the couple and the society, which gets registered on the onset, and therefore the relationship between law and intimacy gets, for a lack of other word, already kind of polluted, or the fact that state is already there in your marriage to begin with, right? Because I'm sure that marriages have patriarchal problems, role expectations, conflict, mother-in-law and society and dowry and the rest of it, even outside of, interfaith marriages, even intrafaith marriages or intra-caste marriages, endogamous caste marriages have all of these problems, which, say, an interfaith couple would also encounter. Additionally, what it also encountered is two different worldviews and two different religious identities, even for the purposes of the state, right? So why I bring this question is because there seems to be some credit that interfaith couples are giving to the fact that they would rather convert and get married outside of the state than stay within their religious folds and then encounter state. So is there, and that then pushes me to the second question, which is Manisha's works question, which is there a certain way in which even interfaith couples are trying to avoid the state and law? Is there merit in thinking out loud that perhaps SMA has not helped interfaith couples at all, as opposed to, say, them working within the frame outside of the law? Yeah, so it's the intersection with law which I'm curious about. Yeah.
Could I respond to that?
Yeah.
So I married 2 years ago. I still haven't registered it. I don't live in Delhi. And any interaction with the state where you demand some kind of registration or recognition of something takes about a year, right? Because I'm not chasing a government official every day. And I've begun to think about this through that sort of personal experience. Uh, who has the time to run around for a certificate for months on end and get other people to be available at the beck and call of the marriage officer, right? Their witnesses have to come twice, and it's very difficult to make claims against the state, right? So where the SMA is working, and it's working in pockets, an interfaith couple, including a Muslim and Hindu woman pairing, may be able to marry depending upon their social location without trouble. And in that sense, their interaction with the state may not involve conflict at the time of marriage making. But any interaction with the state usually does involve conflict. And so making claims against the state is far more difficult than going to the local priest and, paying a little bit of money and asking for a certificate. I absolutely agree, Jigyasa. That is definitely like the stark finding that I'm seeing. Yeah.
I think Professor Shefali will not like the way I've been so anti-state today, but the truth is that, one reading that I can recommend here for the first question that you asked is by Carol Bateman's work, Sexual Contract, that talks about how, I'm sure you are very well aware of that how, institutions of the state are behaving in a manner in the way sexual division of the labor exists. And that is, sort of internalized in the way these institutions work. One is that, so I feel state exists even if you are even if a conflict is there or not. That's what my training has been. I'm going to stick to that. So state exists in the marriage, and this is what we are not realizing when we are in marriage or any sort of partnership, or even when we are living an individual life. State is just there. I mean, we cannot avoid state. So one is a sexual contract actually will help you, all of us, to sort of like go back to this argument in the way how state exists, in the way, how different services that different duties that we are doing and our privileges, how state is constantly there when it comes to marriage, or say situations where the couples are not resorting to special marriage act and rather resorting to conversion procedures, which are very complicated, because from my understanding and from my responses that I have got, it's very complicated and it cannot be relied upon. So even if they go ahead with the conversion method, the point is, one, who made the personal laws, who decided that personal laws are going to work in the family, because it will give certain, obviously certain kind of this thing, protection to minorities. The reason why personal laws exist is that only that, so that a certain secularism, the Indian model of secularism, can be maintained. But personal laws are because of the way the state works. It's state is already there, that's why personal laws are there. One is that. And yes, in cases like Chabanu, we saw when the personal law does not work, you go to the state, you go to the court. But it does not mean the state was not working even then. In any kind of family law, law is essentially an interaction with the state. We are not really realizing that. And it will disappoint us in the way the state is, regulating everything. In the language of, say, protecting fraudulent alliances, sometimes it is behaving as a vigilance. But the truth is, state is constantly interacting with you as an individual or in partnership. So I don't know if this helps, but answer is not going to be very, very, non-complex here.
Thank you so much, Dr. Manisha and Saumya. There is a question in the chat box. I will just read it out for the participant. It's from Deepak. The question is there a theoretical antagonism in calling itself a secular state and then creating legislature on interfaith practices such as marriages? If yes, how does the state reconcile this as regards its self-representation? Dr. Manisha or Saumya, anyone can take it over.
I think Dr. Chachra sort of signaled the answer when
Yeah.
she
I think
spoke about
just repeating the answer that I just said, that, it's one with secularism that India has is also very different. I think theoretical antagonism, when you're talking about theoretical antagonism, then what is the theoretical framework of secularism that India has one? That is very different from the West. Okay, so first we need to like understand that maybe Thomas Bloom Hansen's work will help in sort of refining our understanding of the kind of secularism India has. And then the legislation on interfaith practices, that happened because couples wanted to maintain their religious beliefs while being in a marriage. So I had an interfaith marriage, and we registered two special marriages act. And even though I worked on special marriages act, there were different ways state agents tried to exploit me, and I did get exploited also, because at the end of the day we are looking at the end goal of getting married. So the thing is that although I never wanted to get converted, and that's the reason why I wanted to like use SMA. So I think the antagonism exists only because when we look at the personal laws might impose practices on the other individual which can be restricting, and then which will not allow you to exercise your individual propensities. So which is why that is the propensity, that's the contradiction, and which is why SMA was created, I believe. Okay, and this is how state tries to reconcile its there is no reconciliation. I believe it's a very it's something that is a contestation that will continue, and that's why we need to talk about it again and again and discuss in academia that how this is working and what are the factors that are shaping this. The time when SMA was enacted is very different from the times we are in right now. So what kind of representation are we talking about? Representation for whom? So all of that is also something that has to be looked at. I don't know if I answered the question, but this is what comes to my mind immediately.
Thank you, Dr. Manisha. If you have any more questions, we can take them up, or we can. Oh yes, there is another question in the chat box. Sakshi Wadhwa has typed, "Thank you so much for the insightful presentation. Just two questions. Can you explain more about good faith in the Special Marriage Act? For instance, can it be used or misused to raise an objection to marriage? Furthermore, how does the marriage officer judge an objection raised with respect to good faith? A second question, do you think the state views women as vulnerable and in need of protection in laws concerning interfaith marriages? If so, does this reflect a paternalistic approach by the state?"
So yes, of course, state can constantly do that. State can threaten you. The state agents can, just because you forgot to get a document, the state agent would tell you that I will make you stand. Can do all kinds of things in good faith, and under objection of 30-day period, they can do all kinds of things. And for that reason, you have to be very well prepared, as in aware about the law. You have to have your resources ready. You have to have good lawyers, not lawyers, good lawyers, as in lawyers who are actually, working and advocating for these issues. So another thing is that you were asking whether state is viewing women as vulnerable. Yes and no also, because if we look at Hadia's judgment, yes, High Court is painting Hadia as this, woman who got converted, and she's not, because of her marriage she's converted. So but Hadia's argument was very different. She said that I am converting for my love for Islam, because Islam does not have one particular deity, and that's something, sorry, it has one particular, idea of deity, and I'm not okay with Hinduism as a religion. So when you say that state is viewing women as vulnerable, yes and no, both. It works in both ways, as much as I understand. But yes, there is a certain paternalism that's there. State is a parent, and at times state is working in that fashion also, which is why I made this argument in my presentation that law and state are, or even the institutions of state, cannot be looked at as monolithic institutions. Okay, so there is, a lot of, what we say. There's a lot of contestation there. There's a lot of argumentation. There's a lot of if and but that's happening there.
Sakshi, could you, I wonder if you can clarify the good faith thing that you're referring to. As far as I understand, the objections that can be raised under the Special Marriage Act have to be related to the eligibility conditions in the Act. So gender, age, prohibited degrees of marriage, bigamy, and soundness of mind. If these eligibility conditions are met, then the marriage officer cannot respond positively to an objection raised by somebody. And those are the only basis for judging whether an objection is valid or not.
Just to like add there, but surely, just like Saumya said, that apparently the procedure is for 30 days, but it can take more amount of time because they can delay them and use various excuses. So power works in different ways. You'll know when you use SMA how it works, or you go and use see someone using SMA, that how it is actually, being armed by this thing.
Right, and usually an objection is not filed formally. Objections are made, and the marriage officer might agree with an informal objection of that is not valid in law, and create delays to make the couple wait and make their application lapse. So the formal objections are actually quite rare, and marriage officers may not know how to handle them because they haven't seen a formal objection in the past.
I think there the idea of constitutional morality also becomes very important, that how far they know what is constitutional morality and how far they're working in, cognizance with those notions of the Indian Constitution.
Chachra has raised their hand. Shraddha, you can either unmute yourself or type it. Great. You're not audible. You've not muted yourself.
Yes. Hello, everyone. I'm so glad to be a part of this discussion. It was very interesting and insightful. I have a question. So, I am a PhD scholar and I've been looking into intercaste and interfaith marriages for over a year now. And I've come across some people and narratives around interfaith marriages. So sometimes the way people understand faith or religion themselves, also I believe that may also affect one the way one takes recourse to law. So, for instance, I happened to talk to a person who is a Hindu, a woman who is a Hindu, and she wants to marry a man who's a Jain. So, if you look at the law, then both of them would be under the definition of Hinduism. But then she calls it an interfaith marriage. So yeah, that's what my question is, that how does the way people perceive their religious identity affect the way they take recourse to law?
I think Shraddha, just like to let you all know, Shraddha is, I'm in her PhD committee in Manipal. I told her last minute only, so she joined. I'm very happy to see you, Shraddha. So, Shraddha, the thing is, I think there we need to refer to the works where religion and culture are also linked, cannot be separated. So, because it can be called interfaith marriage from the perspective of cultural integration. If we look at once they get married, there will be different practices that she would be required to, sort of oblige to. So there, I feel Patricia O'Broy's work becomes more valid in the sense like the sociological literature becomes more valid for us to answer this kind of question, because she talks about how cultural differences also, are important. But this can be more of an intercultural or a cross-cultural alliance than interfaith, just because the law is not describing Jainism as, like it's under the Hinduism bracket. I mean, that's what I can think. I'm sure Saumya will have a response.
I
Thank you.
think
Thank you.
with respect to the question about legal recourse, I would say that your interlocutor would not choose the SMA if they could help it, right? Which is the approach that almost everybody has. Unless they are forced into a corner, they will probably not choose the SMA, just simply because how difficult it is to use and how much running around you have to do for it. So in that sense, her own imagination of what kind of alliance, what kind of relationship she's in, if she thinks of it as interfaith, may not be connected to the kind of recourse or the kind of mode she uses to marry.
But that doesn't mean they can't use SMA. I mean, they can use SMA. Should not be. See, SMA is more about maintaining your individual identity in marriage. That's why I was promoting it sort of also, because a lot of us are not aware about this kind of understanding.
No, absolutely.
Just like,
and yeah. I didn't mean to suggest that.
No, I was just like telling Shraddha that she can if she wants to, like, recourse.
Yeah.
Thank you. Thank you so much.
Thank you so much, Shraddha, for your questions and for the speakers to answer them. Do we have any more questions from any participants? I don't think there are any questions. It's been a long session. We are two speakers, the panel. Thank you so much to the speakers for steering the conversation on a very important subject about the loopholes of SMA, something that we don't actually think about because it doesn't concern us. But I feel that it's a very important conversation about how state might actually create hurdles in the garb of creating a constitutional setup. It can actually create hurdles for you in your personal life. And this has been very engaging for us. I also thank our cousin Khushbu for sharing her thoughts and participants for their patience and the questions. We're very grateful for your presence, and we will see you next Saturday at around the same time p.m. for the next event. Thank you so much to the speakers.
Thank you for having us. It was really exciting for me to talk to all of you, and there's a lot of like gyan I am taking from this dark session. So yeah, thank you so much.
Thank you. Thank you for having me as well.
Okay.